Hello, and welcome to This Week in Sociological Perspective. I'm your host, Samuel Roundfield Lucas. On Friday, June 24th, the Supreme Court issued a decision highly anticipated by some and greatly feared by others in Dobbs v. Jackson Women's Health Organization. As the leaked draft decision foreshadowed, the court overturned Roe v. Wade. By any estimation, this is a landmark decision. A day earlier, the court released two other potentially big decisions: New York State Rifle and Pistol Association v. Bruen and Vega v. Tekoh. I thought it might be illuminating to consider these cases together with my guest, Mary Rose. Dr. Rose is professor of sociology, University of Texas at Austin, and former research fellow of the American Bar Foundation. Her research has been cited in Supreme Court cases, including Exxon Shipping Company v. Baker, Miller L. v. Dretka, and Ramos v. Louisiana. Professor Rose, thank you for joining us.
Thank you. It's a pleasure to be here.
So, what a whirlwind 48 hours on the court. I find these three cases interesting, but I admit two of them may be vastly overshadowed by Dobbs, and understandably so. But before we bring in Dobbs, and we're going to get to that and bring that in, can you remind us about New York State Rifle and Pistol Association v. Bruen? And what was the decision, and what was the issue that came before the court?
Sure. This centers on the fact that there really are two kinds of legal regimes in the United States for regulating guns and giving people gun licenses, right? So many states are what are called shall issue licensing states, so that if you go apply for a gun license and you meet the criteria that the state has set out, you're a certain age, you don't have a felony background, any of the other things they've put in, the state shall issue you a license. Okay. Then there's another smaller set of states. I think the court says about 7. There was a little bit of disagreement, but about 7 states in which they're called may issue states. And what happens there is that you go apply for a license, and in New York, the two people that were suing with the Rifle and Pistol Association had applied in their counties to have an unrestricted gun license. They had a license to keep a gun at home. They had a license that might allow them to go to a target range or go hunting, but the license did not allow them to, for example, carry their gun to the supermarket in a concealed manner and have it there for self-defense. So the reason is because in New York, you had to prove that you had a good reason, proper cause would be the term, to have that particular license. You weren't allowed to just get it if you met certain criteria. So it brought in some discretion to the decision makers who issued these licenses. And so the plaintiffs sued and said, this isn't right. This violates my Second Amendment rights. And the court agreed and said that the New York State was not regulated, made its regulations too burdensome for people, and that they're not allowed to do that anymore. That people basically, they're trying to take the discretion out of the decision making. And the other thing they did in this case is really restrict how courts going forward are allowed to analyze these cases. And so just going back a little bit, when they decided Heller, which is the decision several years ago that determined that people have an individual right to bear arms. It's not just if you're part of a militia, but instead that you do have this individual right. When they issued that, courts have been interpreting that in another decision since then, and they did what was called a 2-step process. They would look at the history and what rights did we understand people to have? And then they did something called a means end test, where they would basically look at, well, what's the regulation? What's the state trying to accomplish by having this regulation? And is it the right kind of means for accomplishing that end and what they're trying to do? And is it narrowly tailored? And they would ask all these legal questions. And the Supreme Court in this last case said that second step, that step that looks at kind of the cost benefit of the laws, we're getting rid of. And the only relevant question is one of an examination of history. And so they announced that whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. And that's, you look at whether they impose a comparable burden on the right of armed self-defense, and second, whether that regulatory burden is justified. And so no more of the kinds of ways that courts were used to looking at these laws. So that's the main issue in that case, which is that they basically took away a lot of discretion from governments in who can, they're going to have to come up with categories that would restrict your use. They can't have an individual judge or, in this case, Supreme Court representative looking over these licenses and making a determination about whether you really should, have a right to carry a gun in self-defense. And secondly, the court is really restricting how we look at regulations going forward.
So does this, you talked about the shall cases. I mean, the
shall issue,
the shall states and the may states.
Mm-hmm.
Are they basically saying no more may states?
No more may states. If you want to regulate firearms, you must come up with categorical things that you require of your citizens to do to get a license. It can't be judging whether you've got good enough reasons. And so we're going to see what kinds of things the Supreme Court and other appellate courts allow going forward. So, obviously everybody agrees it's fine not if you have a criminal background not to have a gun. And so that's probably not going to be challenged. Although the margins were you saw Congress debate what's a boyfriend, and if a boyfriend has had an abusive situation with a partner in the past and has gun rights taken away, what falls into that category? We'll have some of those kinds of fights at the margins. Obviously age, but so many questions about what kinds of guns people can own, and under what circumstances, how much. So, new battlegrounds will be on a state like New York that might want to regulate more tightly than a state like Texas, is probably going to start putting in training requirements. So if you want to carry a gun, you have to go to this many hours of a training, or you have to be able to pass a firing test that shows you're good at using a gun. Yeah, and so there's probably categories that even as a shall issue state that they're going to play with to try to make it challenging. But we're just at the beginning, given that we have a new way of assessing these regulations, which is to look to history. We're just at the beginning of understanding what's permissible and what's not.
Okay, well, that's to come. And then there was another case. I guess that was released the same day as the one we were just discussing, Vega v. Tekoh. What was going on with that case?
Yeah, and I'll say, as someone who's read these opinions, it's the shorter one. So if people are hoping to look at it, it's only 26 pages long, because it had a much more straightforward question that they were debating. But it was something that made headlines and people noticed, and it concerns you're right, under the Miranda ruling back, Miranda versus Arizona, and everybody knows this ruling because it's the one on the TV shows where the police are required to read you your rights whenever you're in custody. They don't have to read you your rights right when they show up, but if they consider you in custody or any kind of interrogation situation, they have to tell you that you have a right to remain silent. Anything you can't say. Anything you say can and will be used against you in a court of law, and you have a right to an attorney, and if you can't afford an attorney, one will be provided. So those are all things we And this case centered on an interrogation of a man named Terrence Tekoh. He worked at a hospital, and he was interrogated or questioned by Los Angeles County Sheriff named Carlos Vega. And basically, the accusation was made against Mr. Tekoh that he had sexually assaulted somebody during a medical procedure. I believe someone was in an MRI machine, and there was a claim that he touched her inappropriately. Deputy Vega did not read Mr. Tekoh his rights before speaking with him. During the course of speaking, Mr. Tekoh did basically apologize for inappropriate touching. So he said things that you certainly could see as incriminating. He, in fact, eventually provided a written statement apologizing for inappropriately touching the patient's genitals. Right. So I don't know all the details in the case, because that can mean a lot of different things, and why he would say that, and what his reasoning process was for telling Deputy Vega that. He was prosecuted criminally for unlawful sexual penetration, and even though he was not Mirandized, the trial court allowed his written statement to be part of the evidence against him. So just like the police tell you, anything you say can and will be used against you, absolutely that written statement was used against him. And again, I don't know the details of the case well enough to know why the judge found this an exception to Miranda. We could probably talk for a whole session on the ways in which the original ruling has been whittled down to have fewer teeth. But basically, the statement came in. The jury acquitted, however. So, and in the eyes of the jury, the state didn't prove its case. So I want to say very clearly that this case does not overturn Miranda, right? It's easy to kind of skim through the headlines, and also if you're someone who worries about a court as it's currently constituted as taking away rights, then you might, think, oh my gosh, they got rid of Miranda, but they didn't. They said this. What happened is, after the acquittal, Mr. Tekoh wanted to sue Deputy Vega, right? He wanted some sort of some way to address the fact that his rights were violated, that he was not Mirandized, and he was, in his mind, compelled to give a statement, and he gave a statement without having his rights read to him. And he did, in fact, sue. And so this would be an instance of suing in federal court. It was a state case at the criminal one, and now we move to federal court. And he sued under something known as 42 USC section 1983. So it's part of the federal code that allows you to sue when you're alleging that your constitutional rights have been violated, and under the color of law. And basically, the law says that you have a cause of action against any person who's acting under the color of law, basically any kind of government official, which will include the police, who subjects a person or causes a person to be subjected to a deprivation of any rights, privileges, or immunities secured by the Constitution and laws, right? So that's the formal language in it. He sued under that to say, you violated my Miranda rights. You're a police officer. You did this under the color of law, and so you owe me money, right? I was subjected to this prosecution, and he didn't actually have a lot of luck in front of the jury. The very first trial found in favor of the deputy in this lawsuit, said he doesn't owe you anything. But there was a mistrial in that case. The judge had improperly instructed the jury in some way, so they had to start over. Before the second trial, Mr. Tekoh's counsel and Mr. Tekoh got kind of assertive in asking the judge to instruct the jury in a particular way. And what they basically said is, hey, judge, you should instruct the jury that it was required that Vega violated the Fifth Amendment right against compelled self-incrimination, if you determine that a statement that was taken from Mr. Tekoh was in violation of Miranda, and then that the statement therefore was improperly used against him. So basically, Tekoh wanted the judge to turn to the jury and say, this guy, because he didn't have a Miranda warning, his Fifth Amendment right was violated. You have a right under the Constitution not to testify against yourself, right? That's the Fifth Amendment. And so the judge said, I'm not going to give that instruction. I don't think that's right. I don't think that's the right reading of the law. He gave a different instruction about asking the jury to look at whether the confession was, or the statement was compelled, and whether it was coerced, and those kinds of questions. So this all then went up to the Ninth Circuit, who's, Tekoh lost again. He appealed to the Ninth Circuit, and he wanted the Ninth Circuit to say to the judge, you made a mistake. You should have given this instruction. You should have said that by violating Miranda, you made this a Fifth Amendment violation, and I therefore should, I am entitled to sue, right? So it's a long way of setting the stage for what the court, for this shorter opinion. But what the majority said is Miranda doesn't count. You can't sue for a Miranda violation. It doesn't count as a right that you, that the deputy owed, and that you, that for purposes of this lawsuit. Basically, they said when it's a Miranda violation, it isn't what Section 1983 had in mind. And so this court basically said to Mr. Tekoh, you can't sue for this. Basically, even though they didn't stop calling it a Miranda right, they basically said, well, you have a right for the police to give you this instruction because you shouldn't self-incriminate, right? And so they called it a prophylactic right. They said basically or a prophylactic rule. They basically said this rule is something police have to do to help you not incriminate yourself, but it itself is not a constitutional right. The dissent vigorously objected to this. They on all sorts of grounds, but they basically said, you can totally sue for this. This is a right under, even if you don't call it a constitutional right the way the Fifth Amendment right is, it's a right. You're supposed to get this from the police, and if they deprive you of it, you should be able to sue. But the court said it doesn't count. Basically, it doesn't count for purposes of a lawsuit like this. So that's that case. It basically made it the end of the line for Mr. Tekoh. He did get acquitted, but he didn't have any jury recognize what he saw as a violation.
But one thing I'm wondering is, so this is very speculative, I guess, but if the judge had not let the confession come in or the statement come in, by the logic of the plaintiff, Mr. Tekoh, would he still, because the Miranda rule or the Miranda rights, whichever way, was violated by the detective long before the judge ruled in favor of the statement coming in. Mm-hmm. So was it the statement being allowed in that sort of, I don't want to use the word trigger, but okay, triggers the request for some
like a remedy?
Remedy, or is it the original violation?
I think that's a great question. I think your instinct is right. I think that suppose in another world, he gave this statement. He said, I apologize, I inappropriately touched this person. And then, nobody disputes that he wasn't Mirandized when he said that, right? If the judge, in looking over the totality of the circumstances, said, hey, police officer, you should have Mirandized him, and the penalty for you not Mirandizing him is I'm throwing out the statement, right? Mm-hmm. And probably there wouldn't have been a case to go forward without that statement, or it would have been a pretty weak case, right? I mean, I think it just by the fact that there was an acquittal with the statement tells you that there were probably some facts that involved a lot of interpretation here, right? So I think, there's a real chance he probably wouldn't have been prosecuted without the statement. And so I think what this says is it's a little bit why the majority ruled the way it did. It said basically you have a right to Miranda, and the police are deterred from violating Miranda because they don't want the evidence thrown out, right? So that's that prophylactic rule idea. It's to protect. And, they give this this warning so that you won't self-incriminate, and if they don't give the warning, then the defendant is also protected by having the statement out. Well, we've whittled away Miranda so much that even without it, sometimes these statements come in. And again, I didn't have time to see all the reasons here why it came in. But basically, these things can happen. What the court is saying is you don't have another remedy for addressing it through the civil lawsuit.
I see. So I presume that had he been convicted, then there would have been this would have been an appeal issue.
It would have been a state appeal. It would have been on the issue of whether that statement should have come in. So, and obviously the judge believed he or she had some reason for bringing it in, and so it's hard to win at the appellate level. But yes, it would have been a state court issue. It went into the federal court because he wanted to sue under this federal law.
So those are the first two cases I wanted to engage, but now we come to Dobbs, which has gotten a lot of attention.
Yes.
So you would think, everyone is on the same page, but actually I've heard conflicting accounts, or actually what we'd say conflicting counts. I read one news outlet that said the decision was 5-4, but I thought it was 6-3. I think they're just counting up who signed on to that majority opinion. So to just make sure we're all on the same page and make sure that I'm understanding, what was the ruling in Dobbs? What's going on there?
Sure.
And then I have some other questions.
Yeah, sure. No, it's a really, really important question. It's a really important distinction. And it's something that it's kind of hard to get your mind around. And if we had time to talk about the leak, it's implicated in this. So basically, whenever you're looking at a Supreme Court decision, you're looking at two issues, and votes matter for two different issues. One issue is who wins this case, all right? So on the question of who wins this case, it's a 6-3 decision. Okay, so 6 justices believe that the state of Mississippi should be able to regulate abortion such that they're allowed to say you can't have an abortion after 15 weeks. So there were absolutely 6 judges who said that. The second thing where votes matter is why. What is the reason that we are saying that Mississippi can do this? And there were only 5 votes for that. And the 5 votes all agreed that in order to reach that conclusion, you needed to overturn Roe versus Wade and Casey versus Planned Parenthood. Justice Roberts did not believe that you needed to do that in order to decide for Mississippi. He thought you can just decide for Mississippi and agree that you can regulate abortion after 15 weeks. And basically you can overturn a piece of Roe, which is this viability rule that you can't restrict up to viability. And he would say, I think you can get rid of that and keep the basic right to an abortion up to 15 weeks or whatever we're going to argue about next. And so I would fine for Mississippi, but not for the reasons that the other people are doing. Does that distinction make sense?
Yeah, yes.
Yep. So that's why you hear different vote counts. So one is the result and one is the reasoning, and that can really matter. We've had cases in the past that, for example, people who know the Bakke decision from California overturning affirmative action, there were all these votes to say University of California could not engage in the kind of affirmative action they were doing, but nobody could agree why. And so we actually didn't have 5 votes for a reason in that case. So that can happen.
Well, the question for this for Dobbs is the reasoning in the Roberts, and I haven't read
the 230-page opinion.
I read the original opinion, the draft, but I didn't read the revision because I was thinking, I wonder, or the new, the released version. I wonder, is it exactly the same, or did he modify it at all, or they modify it? But what I'm asking now, and I haven't read this, is the Roberts concurring opinion, or concurring in the judgment, and whether it would turn out that that's a nice set of words, but it actually provides grounds to end up overturning Roe v. Wade just down the line.
Absolutely. I think people see what Roberts was trying to do as, some people agree with him, but some people feel that he's not being fully honest about what his end game is, that he plays a very, very long game, and he wants to avoid overruling things, and instead incrementally reach a result based on law. So we ruled this way, and now this new case came, and so the example, we said 15 weeks, we got rid of viability, so now we're saying 15 weeks works for us. Then some state government says, well, we don't like 15 weeks, we like 10 weeks because we've decided that's when a fetus can feel pain, right? So now we have 10 weeks. And so it would go up to the court, and the court would decide, is it 10 or is it 15, right? And if he was able to come up with a reasoned decision why it was 10 instead of 15, then you'd go to 10. And and that's basically what the majority, nobody signed on to Justice Roberts' view. The majority thought this is just getting, it's a slow motion way of getting to where we're saying that Roe was wrongly decided. And obviously the dissent didn't think that you should overturn even the viability standard.
Yeah. So let's talk a little, you mentioned the leak. What should we make of this? How should we be examining, what does this mean for, most of us are not on the court. And even most of us are not clerks or involved with the court at all. So we're just sitting here from the outside looking. And so I'm wondering, what does it mean? What should we take from this?
Yeah, I think it's hard to overstate what a big deal that leak was. It is a very, very concerning sign about the way the court is working right now. And I'll be the first to tell you, I don't know who leaked. And there are really two competing theories. One theory is a liberal, if we, putting quotes around things, but generally Sotomayor, Kagan, and Breyer are the liberals on the court currently. So either one of them or one of their clerks, which is the more likely person, leaked this to sort of scare people and get people out in the streets and, let people know this is coming and mobilize, and maybe that might affect the court. So that's one theory. And in that case, it was basically trying to undermine private discussions, the back and forth the justices do in deciding a case. Votes change. They really do. They meet in conference, they take a vote, they decide who's going to write the majority, who's going to write the minority, the dissent. People form alliances, but it can change over time. So a leak is a very big deal. The other theory that would implicate the six, not probably the five, because I really, really, really don't think Chief Justice Roberts had anything to do with this leak. But that argument was, and it circles back to this question of why do some people say 5-4 and some people say 6-3. One argument was, if Justice Roberts could have gotten one more justice to side with him, there wouldn't have been, the only thing that would have happened is that Mississippi would be able to have its law, but Roe would not have been overturned. If he had gotten even one more vote from the majority on his team, then Roe would not be overturned, because there wouldn't have been 5 votes. There would have been, it would have been 4 to I doing it right? 4-2-3.
Had a plurality, but not a majority.
Right. And the rule is if there isn't this majority on the reasoning, then you go with the most narrow reasoning, which is Justice Roberts' reasoning. So the theory from the other side is no, it wasn't the liberals. It was one of the people in chambers who very much wanted Roe to overturn. And they leaked in order to freeze the votes where they were. Because basically, and most people who speculate on this, and again, I do need to say I'm completely speculating, but most of the people who speculate on the leak look at Justice Kavanaugh and say he was the one who seemed to be wishy-washy. And so by leaking in May or April, I can't remember exactly when it was, by leaking, you make it hard for someone to move to Justice Roberts' side, because basically the entirety of the pro-life movement has had this taste of what the decision could look like. And when it's finally issued, it's clear somebody jumped ship. And so the argument was the leak was to freeze the 5 votes.
Yeah. Well, that's interesting, because I would think it's not helpful to leak from the left, because the court is not, my guess is, why would one more set of demonstrations move them any more than the last 50 years of demonstrations? I don't think that makes much sense. That doesn't mean somebody didn't do it.
Yeah, agreed.
It would not be, doesn't make a lot of sense to me.
The other evidence against it being from the 3 liberals on the court is that you'll note that the opinion was from February, right? The leak didn't happen for at least 2.5 months later. And so the question would be like, well, if you were going to leak to mobilize public opinion, why'd you wait so long, right? And so the timing favors more the idea of that somebody was trying to freeze votes. And again, that's just one theory, but it has sense, because I do want to emphasize it's such a breach. And Clarence Thomas has spoken on this publicly, that it just shattered, people's trust in each other. I don't know if he's, if he somebody in his chambers was a leaker, or if I don't know who it was, but he certainly personally feels that the comedy on the court and the teamwork they feel was severely undermined.
There's the justices, but the clerks, I would imagine that a clerk is generally close to you should correct me if I'm wrong, because this is, and again, I'm definitely very much an outsider, but I just imagine that a clerk is reasonably close to the judicial approach or political leanings of the person for whom they clerk, but that wouldn't mean that they're 100% in alignment on every single thing.
Oh yeah.
So I would imagine that a clerk, from unbeknownst and unconnected to not coordinating with the judge for whom they're clerking, could have leaked it. It doesn't just, and that could be anyone. Someone on we're clerking for one of the judges who are identified with the right, might agree on a lot of things but not agree with this decision, or have the same motivation. It could cut either way. And the same thing, the judges clerking with the clerks working for the judges on the left could, the judges themselves might be, we would never do this, this is going to destroy it. But they are new and they're only in the institution a few years, or not nearly as long.
Even shorter, one term.
Right. One term. I wasn't sure if it was 1 year or 2. And so they don't have the same historical, the same temporal interest, and they could have leaked. So it's just really hard to start identifying, and we do allegedly live in a country where you're innocent until proven guilty, so the justices should really be given that same
Yeah, absolutely. We don't know how it happened. And, I suppose there are other arguments besides, I don't know enough about how opinions are passed around, whether somebody could have been at a photocopy machine and been like, oh my goodness, I don't really know the inner workings enough to know who outside of, the people who typically have their hands on it would be the justices and their clerks. Because the clerks do a lot of the writing for their justices. So the clerks do a lot of writing for their justices.
Well, when you look at these three cases together, what jumps out at you, if anything, as you consider them?
Yeah, so I was thinking about this from an audience for this program, which is sociologists. And I asked myself kind of what themes I saw and what issues seem to be most relevant to our tribe, to sociologists, and others interested in the topic of sociology. So one issue that I actually think is getting a lot of attention, a lot of discussion, so I wasn't going to spend as much time on, is just the basic notion of legitimacy of the court. I talked about this quite a bit in our last conversation, but the court does need legitimacy to function. If the rulings are not regarded, or the court is not regarded as legitimate, it doesn't have an army to send out. And we certainly saw that during desegregation, that a governor in Alabama would say, I'm just not following this, right? And then it's on the president to decide if the president is gonna send out the National Guard to enforce it. So the court doesn't have its own way of enforcing its decisions. It's reliant on the other agencies to see its rulings as binding and to accept them and to move on. So there's been a lot of talk about whether the Dobbs ruling in particular has so undercut the court's legitimacy that it won't recover. And there's been talk from the bench. There's been, so Justice Sotomayor asked this in oral argument. There's certainly been conversation over the weekend and going forward. So that's one. Obviously, anybody interested in public opinion of the courts, people's understanding of law, would be interested in that topic. The other two that may be less clear or of interest center on how we define what a right is, right? Like, that's fascinating to me and part of my field in the law and society tradition. And the other one I'll talk about in a second has to do with methodology. But let me talk about rights. Basically, we've known for a long time, social legal scholars have known that whatever the court writes, the court or a legislature gives you a right, gives you some power under the Constitution. It's something that's written on the books, but that doesn't mean it's lived in a way. Or it is funneled through social life, through the society you live in, through your place in that society, through all the things that structure life about where you work and your opportunities and everything, all the other intangibles. Rights are just like that. They have a social construction to them in so many ways. And so these decisions as a set really get us to start asking, what's a right? When do you have one? When can the state take it away? Or in the case of Tekoh, when does that right not count in the same way some other right does, right? It doesn't let you sue. And all of these cases are really, they tell us what the state of rights are on the books, for sure, right? Like they saying you don't have, you don't have a right to sue under, if the police don't respect your Miranda rights. So they took that away. They said to governments that you cannot regulate firearms, that people have a right to firearms such that you can only regulate them very narrowly. And then obviously in Dobbs, what it said is what the majority said is this is up to the states. That basically there's this big fight between women who want, who want autonomy over their reproductive life, And then there are states that have an interest in what the court calls unborn life, but fetal rights, basically, and fetal interests. And the court answered that we are now siding with the states. We're saying that the states get to, through their elected officials, get to determine what the rights are in that state. And so you see there's all these questions from this about the state of, what does it mean to even have a right? What does that mean and who gets it? I think one of the concurring opinions that maybe hasn't gotten as much attention in the press by Justice Kavanaugh had to do, he wrote separately from the other justices to explain why he felt that we needed to overturn Roe and Casey, and that basically he said, this should be, that he feels that when those cases were decided that the court was picking a side, and that he doesn't want the court involved in this. He feels that the state should pick a side, not the court. So he's trying to kind of construct the court as neutral, and that this gets us back to neutrality. The courts aren't determining who's right in this. He also said that that he believes that going forward, there will be restrictions on what the government can do to regulate abortion. And one of the things he said very specifically is he doesn't think it will be illegal to travel to another state to get an abortion. So to go from Texas to New Mexico, because we have a right under the Constitution to interstate travel. And so he's saying you'll have a right, you just have to travel to get it, right? And I think that raises all kinds of questions about what a right is when you have to have the resource. I don't know if there has been as stark a claim in law. I don't know my rights literature well enough, but I would be shocked to find so clear a statement that rights depend on resources. That if you can travel, and in some places it's not driving 9 hours across a border, it's having to get on a plane. That your rights depend on the resources, whether that's money, transportation, time, all kinds of things. It was, I think he thought it was being hopeful and moderate and, don't worry, they can't, states can differ on this and it'll be okay. But I think it says something remarkable about who has rights and who doesn't. So that was one issue. I think the New York ruling is going to pit gun owners' rights against, I think, a lot of people's construction these days of the notion that they feel that they have a right to safety, and that they feel that they, particularly in public spaces, that should be a right, that should be something that's recognized. And it's going to be interesting to see how much pushback, if any, there is from people who are maybe kind of fed up with living in a society that is so awash in guns that you really just cannot know whether, you're behind someone in a grocery store with a gun. And, obviously the gun owners would say you shouldn't worry if you're behind a gun owner in a grocery store, they're fine. But I think people are very upset by this, just how much gun violence there is in the United States. And we don't look like any other country except those at war in terms of the risk of dying by gunfire. And so I'd be very interested to see, the court has shut off in some ways ways to regulate this. It has said New York and these other may issue states can't do that anymore. They can't have discretion in their decision making. And we already know that Congress is just horribly gridlocked. We got a little bit of breakthrough last week, ironically, on the same time that this ruling came down, but it's not much, And so I'm interested in how people construct an alternative right to the Second Amendment rights and how that plays out.
It's interesting because the New York State, by saying no may states, so you have to have a categorical
exclusion.
exclusion. they're saying rights are not matters about which people can use discretion. You just have them.
You just have them.
But in Vega, they've removed Miranda from the constitutional right. You have a right to not to you have the right not to self-incriminate yourself, but you don't have a right to this particular mechanism of that the denial of if the failure to read you the Miranda warning does not constitute a violation of a Fifth Amendment.
That's right.
Right.
It doesn't.
It constitutes something else. So,
yeah.
And then Dobbs, they're basically saying, well, the right is going to be conditioned if it is, well, basically they don't find a constitutional right.
They don't find a constitutional right.
Abortion. So everything that would have been grounds for a right somehow doesn't apply. I mean, there's the privacy right. There's a privacy right, allegedly. Other people would put a bodily integrity basis for it. There are probably other bases, but none of them are sufficient to make that a constitutional right.
They said that that interpretation of rights was wrong. By overturning those decisions, they very clearly said, basically, Roe grounded the right in the First, the Fourth, the Fifth, the Ninth, the 14th. It had all these, it's basically like you have a right to privacy from all these sources. And Casey didn't mess with anything but the 14th Amendment, which has to do with equal protection under the law and what's known as a due process clause in that. And there's a notion of you're having liberty. You can't be deprived of liberty without due process. And so the question centers on what's liberty, right? And Casey found that this fits, that its ability to exercise reproductive freedom and have choice and decide it with your doctor fits under that notion of liberty in the 14th Amendment. And so do other rights since then, same-sex marriage, the right to engage in particular kinds of sexual conduct between consenting adults, and the original Loving versus Virginia interracial marriage case, as well as some contraceptive cases, all center on the same idea that this is liberty, this is you being free. And the court resoundingly rejected that for abortion. At least 4 of them said that's not relevant for abortion. The other one was Thomas, who said, the majority, the main opinion by Alito took great pains to say, don't read too much. And in the leaked draft, you saw that as well, that, don't read anything into this about other rights. This is only about abortion because abortion implicates a fetus, right? And so it's all about, who gets to decide, and we're putting that back to the states, right? And Clarence Thomas really was not on the same team. And he wrote separately to say, pardon my French, hell yes, we should overturn these other rights, that we definitely, he finds the notion of substantive due process to be an oxymoron, that basically you're just entitled to a fair procedure. There's no guaranteed outcome of what the law should look like. And so he would get rid of he didn't mention Loving versus Virginia, because I guess he's assuming no state is going to try to resurrect the anti-miscegenation laws. But he did mention specifically both of the rulings that protect gay men and women from the police arresting them for having the wrong kind of sex, and also right to marry. He would tackle some of the decisions that have said that states cannot regulate contraception, certain forms of contraception. He would do away with that as well. And so it is the Wild West in terms of what liberty means on this.
When you said the wrong kind of sex, you meant that in
oh, please, in score, yes, definitely in how states define it for purposes of regulating. Yeah, no, I apologize. That was a thank you for correcting that. But what I meant was the state says that you can't have this kind of sex. It's the wrong kind of sex, and so we're outlawing it, a sodomy law, basically. And Lawrence versus Texas overturned that.
Well, you mentioned there was another element, another continuity.
Yeah, I did want to say one more thing about this notion of rights that I think sociologists should be interested in, that I really saw in the Tekoh case. Now that you don't have this right to sue, that's been taken away under federal law, I just think it reminds us again and again that you don't have a Miranda right unless you exercise it. That really the court time and again makes it. I mean, you have a Miranda right, but if you really want to maintain silence, you have to do that. And I talk to my students a lot about this. So I think the rights issue that came up in that case for me is it just reminds me how much rights are deeply dependent on being a certain kind of person who will assert them. And Miranda and the right to remain silent is absolutely a place where you have to tell people that obeying the law in that instance means not doing what the police want. And that's a really difficult thing for people to get their minds around. But obeying the law is not talking to police when you feel like you are in a custodial situation or some kind of interrogation situation. And that is right. You get to not talk to the police, but it takes a certain kind of person. And Catherine Young at university, she's been at UMass Amherst, moving to George Washington Law School. She's written using Bourdieu and the notion of cultural capital with a co-author to show that, certain kinds of people feel more entitled to exercise their rights than others. So it does have a very social piece to it. So that was the other point I wanted to make about rights. I think the other theme that I think sociologists should really pay attention to and be a little bit afraid about is that Dobbs and the New York case were very, very clear in rejecting the methodology and the kinds of data that sociologists look to in deciding and making judgments about things. And basically both of these decisions put an extraordinary premium on a rights analysis based on history. And that basically your rights are whatever was true of your rights at the founding, so in the 18th century, or in the case of abortion, at the 14th Amendment. And there's an argument about why they picked one for the Dobbs case and the founding for the New York case. But basically, those are the places that you should look to decide what your rights are. And in the Dobbs case, they said you don't have a right to abortion because you didn't have a right to abortion at the time of the 14th Amendment, which is 1868. For the New York case, you now have to assess government regulations by looking at what the history of regulation is in this country, including whatever we did when we were a predominantly rural, unpoliced set of states, right? And in both those cases, listeners may know that Justice Breyer is very fond of social science research. He often buttresses his own opinions, his concurrences, his dissents with social science data. And that was true in his participation in the Dobbs dissent. And it certainly was true. He wrote the dissent in the New York case, lots of demographic information about rural versus urban, and lots of statistics about gun violence, and lots of things that we social scientists look at when we assess a law. And in both those cases, Justice Alito really smacked down the notion of using those kinds of things. He called them irrelevant in one case, and wrote separately in the New York case to say that the dissent gave a lot of irrelevant things about gun violence. Doesn't matter. Doesn't matter what the state of gun violence is. Doesn't matter that guns put you at risk for suicide and cause just so much harm. Doesn't matter. And instead, the question is, what was true at the founding? And what did the founders want us to have in terms of arms? And asking judges to do a historical analysis. And I really think it's concerning to me and it certainly was concerning to the dissenters. Historical analysis is the kind of thing that's a little bit easy to cherry pick. I would love to be a fly on the wall at the next Law and History Convention, or the American Historical Association Convention, as they unpack all the power that they have given to historians to decide what the nature of our rights are. And it was very clear that they reject. There were several historians who submitted briefs about what the nature of the law was, or the nature of history is, about guns, and those were rejected and not paid attention to by the court. So I think there's some question about whose history they're gonna privilege. And then just more basically, our rights are kind of determined by a time in our history that we were not a perfect union, by anything close to it. And you have real concerns by grounding your sense of what your rights are at a time when we owned slaves, when women couldn't vote, when so many things were deeply, deeply problematic about our society, but that the court has, in 2 cases, basically anchored what our rights are currently to what was true a very long time ago. And I think sociology and social science data more generally really got marginalized in these cases.
It's interesting. So are they, it sounds like they're rejecting, I mean, correct me if I'm wrong, are they rejecting or let me know if this is, are they rejecting the history? I mean, it sounds like they're embracing the history, but rejecting the historians.
Yeah. So, and I mean, that's what I mean. Like, Justice Breyer wrote beautifully in the dissent in the New York case to say, like, I look at history different than you. I conclude something very different. And after Heller came out, the original ruling that found an individual right, here's all these articles that said you did the history wrong by historians. And so he wrote to say, it's easy to get this wrong, not because history isn't, it's just complicated, right? And there's you miss a document and that could really change your analysis, right? It depends a lot on whose history you listen to. And it's also the case that judges at the lower courts don't have the resources and the time to become historians, right? And so it's gonna punt things up to the Supreme Court, and they're not historians either, but they certainly get a lot, amicus briefs sent their way. It's very concerning to me that so much of this is about the history that Justice Clarence Thomas tells, the history that these other justices tell, and that it makes me pretty concerned. Not that I don't trust history. I really want to make that clear. It is one way that has informed law, but for them to say these other things like a cost-benefit analysis, look at the impact of law on people in the world, it feels like that should be part of it. About the nature of our modern society and our understanding of who we are now should be part of it. History really got privileged, and I have a lot of concerns about that.
I mean, I know that it's easy to make points about, or raise questions about, this technology didn't exist. Pick your technology, reproductive technology, communication technology. And so I know there's sometimes tendencies to try to figure out, what's the closest analogy if we go back, 150 years.
Yeah.
But being able to do that is not necessarily damaging when it's also informed by other information, like, what are the elements of the technology, how it is operating now? And you're saying that second set of things is going to be, at least if it's consistent with these rulings, foreclosed. They're just not interested in that anymore.
I really had a hard time in the New York case getting through it and understanding what Justice Thomas was telling us to do, because it is really not clear. And he did say, there'll be new weapons that they didn't have at the founding, and new technologies and new kinds of regulations, and of course you have to analogize. That's going to be part. You won't look back at the founding and find this exact weapon. So of course you're going to have to find analogies, and you're going to have to, but it doesn't have to be a perfect match, but it also shouldn't be too much of a stretch. And I mean, there's so much room for interpretation that is in line with, we want more guns, we want less guns. I mean, it's whatever your position is, it really, the conservative court has always been very deeply, deeply critical of, kind of these tests that judges come up with. This one, I really struggled to understand what judges are supposed to rely on. when you ask a simple question such as, can a state ban assault weapons? Okay, well, you're supposed to find an analogy, and what was, well, we didn't have assault weapons at the founding, but is an assault weapon analogous to this, or is it analogous to this? And what you make the analogy to is going to determine whether you're allowed to do this, separate from how much damage these guns are doing, right?
Well, I know you touched on this earlier, but I need to go back to it.
Okay.
If we could magically live in a world where the Dobbs case was never brought, but we still had the rulings in the other two cases, would the court that issued those decisions have a legitimacy issue?
I think the gun one is coming when it did, and being so tone deaf to, to just the scale of mass shootings that we're having that are not happening in countries with fewer guns. I think they would, there certainly would be some grumbling. I think, because it forecloses another way of fighting back as a citizen who may want this kind of sense of less risk from firearms in public spaces. So I think they would still certainly have taken a hit and looked a little bit political. You throw in Dobbs and it's just off the charts. And I think the dissent pointed this out very clearly, which is, they take very different positions for these cases. So just a couple of examples, obviously they threw out, they argued precedent for the gun case. We said in Heller, we said in McDonald, therefore you have to do this, and obviously the precedent of history. Whereas in Dobbs, it was like, nope, don't care that this has been the law of the land for 50 years. So that's one thing. When they looked at historical data in the gun case, they looked at the founding and said, well, the 14th Amendment doesn't matter so much because, and they have all these reasons why you shouldn't worry about the 14th Amendment as much as the founding. And of course, that's convenient because there were a lot more gun laws by the time of the 14th Amendment. There's a lot more regulation of guns by 1868. States were Texas had a quite strict gun law. And so there was, a lot had happened since the founding. So they sort of, minimize 1868 for that case. Whereas in the abortion case, it was all about what was true in 1868 because there were a lot more abortion regulations in 1868, whereas abortion was more common in the early parts of pregnancy at the founding. And so they look like they're cherry picking. They look like they're picking a time that they want to compare it to that's favorable. And I say all that to say, I think the back-to-back of those two cases really undercuts legitimacy because when you read them next to each other, they would say the right to bear arms is in the Constitution, abortion isn't, period, end of story. But I think there's a lot of ways to compare those cases that make them look that raise questions about legitimacy when you read them next to each other.
Well, when a court has a legitimacy crisis, what happens? Can the legitimacy be restored? How does that happen? Or is this the end or, part of the end of the prospects of democratic government? And we see what's happening in the January 6th committee and there's all, it's just very concerning. What would restore the legitimacy of the court, or is this really kind of a done deal for the foreseeable future?
It's a really hard question to answer because the rulings, and it probably has been clear, I'm pretty critical of them. And so obviously they have less legitimacy in my mind, but even separate from that, the rulings themselves are not taking place in a vacuum, right? They're taking place in a highly polarized society where compromise is a dirty word, right? So the notion that you would, exactly what happened in Casey, where conservative justices came together kind of with more liberal justices to, to hammer out something that was more of a compromise on this and introduce this notion of an undue burden, but kept the right in place to an abortion. That's, been sneered at, and the notion of compromise or any kind of middle ground is sneered at today. I think you can't divorce who issued these rulings from the very anti-normative practices that the Senate engaged in having Donald Trump have 3 nominations on the court, denying Merrick Garland's seat during the Obama administration on the argument that we should wait to the election, but then turning around and installing Amy Coney Barrett within a week of the election. There are sort of norms that are being broken all over the place. So this ends up being a piece with those. And so I think I feel that it's more kindling on the anti-democratic fire, that it erodes trust in institutions, it erodes trust in a sense that the law is constant, can be, a source of protection, that your rights are secured. I think some of us, certainly from the Dobbs case, do not feel that those rights that they're at the whims of the political world.
You said that, you have misgivings about these cases. You would have decided them differently, I suppose. But there are cases all the time in the Supreme Court and every other court that I might disagree with. That if I were brought in, subject to a case, they might decide against me, but that wouldn't necessarily make it illegitimate.
That's right.
You go along with it. You think, I had my day in court. That's the saying. I had my day in court. Whether, you won or you lost. And it's that accepting it when you lost.
Yeah.
That is the sign of you. It could be the sign of just you don't have the power to rebut it. But usually it's a sign of accepting the legitimacy of it.
That's
so
right.
if we aren't accepting the court as legitimate, and there's going to be more guns, it doesn't sound like a positive thing. This is a heavy topic. Let me turn to one more. I'm happy to go, but I have one more question for you.
Sure.
You said a little bit about this, but returning to the 3 cases, as you think about them, are there any next shoes to drop that we should be looking out for, or not to say that they're certain to fall, but that we might look to see if they do fall?
Yeah, I think the Tekoh case probably you can take out, because I don't necessarily see a through line to other things they're going to say. Nope, that doesn't count. You can't sue for that either. There may be. I wouldn't know well enough. For the others, I think, yeah, lots of questions for down the road. So beginning with the New York case, what are states allowed to regulate? Like what, if we're doing this history analysis, whether it comports with our understanding at the founding, what can we do? Right? Like, so just taking the boyfriend, like that you could take away guns from someone who has a domestic violence charge, including if it's an unmarried partner, and I'm saying boyfriend because that's the statistics. It's not, boyfriends tend to do the more harm, even if there's violence from both sides. So the, is it constitutional to say to somebody, well, you hit your girlfriend 5 years ago, and so you can't get a gun? That's okay. Could you say you hit your girlfriend when you were 19, you never get a gun? I'm sure there are people who might say, well, that's not really fair, but maybe we want to know if you're still hitting your girlfriend. You just haven't been caught, like what are the ways that we might assess who is safe? Because we've really gotten it wrong in a few very strong cases. What are these kind of categories that states can develop that allow them to restrict the rights? I think as much as the court says this shouldn't be in the hands of judges, it's in the hands of judges and historians that they like. That seems to be what I'm hearing. On the abortion side, on the Dobbs case, so many things. So obviously, if your rights depend on where you live, then what happens when you go across state? What happens when someone helps you go across state? there are ways to induce an abortion through medication that were not true at the time of Roe. Who can send you those pills? How can you get those pills legally? And the states who feel very strongly there should not just be abortion should be difficult, but should be gone, will have an interest in prosecuting people who provide pills, prosecuting potentially the women who take them. I think we're going to have a lot of questions raised about what neighbor states can do that facilitate access to abortion by women from states that ban the procedure. And then there's a whole separate question about the fact that we overturned a precedent that's grounded in privacy and autonomy, and the substantive due process issues. And Clarence Thomas basically invited people to come up with cases that the court could consider. Now, it's not clear that Thomas even has the votes to hear the cases, let alone have them go in his direction. But that was a pretty strong invitation to revisit things that we take as settled law. And I mean, it's one thing to say you can't get an abortion in one state versus another. It's another to say that your marriage is up to the states. That's crazy. And so I don't know how you're married in California and then not in Texas, how that works. And so I think there's just so many unanswered questions.
Yes, they've opened a Pandora's box.
Yes.
Multiple ones, actually.
Very much.
Professor Rose, I want to thank you for coming on and talking with me and sharing your thoughts about these very, pivotal, landmark is too weak statement about just dramatically transformative. And we need to do a lot of thinking about this, and people need to, and I appreciate you coming on and helping me think about this and giving me a lot to think about. So I appreciate it.
Thank you. I really enjoyed our conversation.
That's This Week in Sociological Perspective. We'll be back next week with another interview with an author of some important sociological research and more sociological insights on an issue in the news. Till then, wishing you a relaxing, indeed a liberating Independence Day weekend. Take care.